Ruben Schwartz here from Sales for Nerds, kicking off the Sales for Nerds podcast. If you feel more comfortable with SQL than sales calls, more at home writing test suites than proposals, more interested in crunching numbers than shaking hands, if you think networking should be about routers rather than cocktails with strangers, if you're more interested in debating code editors than negotiating deals, but somehow you ended up responsible for some of those sales and marketing activities, this is the podcast for you.
Today, I'm super excited to have Brian Spross with me. And Brian, how often do you have people tell you that they're so excited to be talking to a lawyer?
Never.
Never? Okay, well, there's a first time for everything. And thanks for coming on the show. And today we are going to be enjoying a 2014 La Posta Malbec from Argentina.
That sounds delicious.
Let's see. Works for me.
Perfect for me too.
And what I always say at this point is, gosh, this would go so well with some steak. And maybe at some point we'll up the production values of the show and go to wine and steak. But for right now, we just have to suffer through with the wine.
I can deal with just wine. That's fine with me.
All right. So a little bit about Brian. He's an attorney who specializes in technology law. He's worked with everything from giant Fortune 500 tech companies through startups, dealt with agreements and deal structures and licensing and consulting and outsourcing, entity formation, funding agreements, outsourced general counsel, et cetera, et cetera. And we're talking about companies from startups all the way through companies like McDonnell Douglas and Lockheed. So he's got a huge breadth of experience, but focused on technology. And Brian actually has a bachelor's degree in mechanical engineering. So he is, I think he's a nerd like us, but we'll see. Maybe we can test that a little bit. One of the reasons that I was really interested to talk to Brian was almost worse than sales. So, all these tech people, when they get into business, they sort of have this aversion to salespeople, like they're evil, lying, conniving people. And sometimes that's accurate. And if there's anything worse than sales in sort of the mental image, it's the lawyers. And when I started my company, I was talking to a lawyer and he helped me set everything up. And the thing that was most amazing to me was after talking to him, not only did I not feel like it was some kind of necessary evil, he actually made it sound really necessary and helpful. And it was just a wonderful change of perspective for me. And it made me think about the law in a whole different way. And I know from talking to people who start their own businesses that a lot of them still have that mental picture of lawyers as people who want to come in and steal stuff. And I thought maybe we could dispel some of those myths or confirm them or whatever the case may be. But Brian, tell me, when people start a company, what kind of legal issues should they be thinking about?
Well, the first one, Ruben, and first, thanks for having me. This is terrific. The first thing you should think about, and the reason you form a company, is actually protection. You want legal protection for what you're doing. The reason you spend the money with the state, in Texas it's $300, the reason you spend that $300 is to protect yourself personally. So nothing that you do as a business affects you as an individual. Now, obviously there's some ways around that, but in general, if you form your contract with the state by filing a fee, $300, you get the liability protection. That's actually number one. And that's my number one reason to form an entity. And I have friends come to me all the time and say, I don't need an entity. I'm a sole proprietor. Why would I want to spend my money? And I tell them it's $300 and it's not much more than that. Even if you use LegalZoom, it's still very, very little more than $300 and you get the peace of mind. And I tell people the reason you need it and the time you need it is 1, when you have a customer, 2, when you have a vendor, or 3, when you have a user of anything. Because that's when something could theoretically go wrong. Hopefully nothing will ever go wrong, but could theoretically go wong and create liability for yourself.
So basically, anytime you have any notion of what I would call an actual business, you should have an actual business.
Absolutely.
Is that a fair summary?
That's a perfect summary.
All right.
And I even go a little step further. Any time you're doing anything that sounds like a business,
okay,
that's when I would start my business.
So before you have an actual business, start your business. That is the correct order, I believe.
That's exactly right.
Okay, that makes a lot of sense.
And then I have a second part of that, which is do it right. So you can use places like LegalZoom, and there's no problem with that. You're getting your original documents, and it works perfectly fine, but do it right. And what I tell people is the cost for me to redo what you did wrong in the first place is about 5x what it would have cost in the first place. So, and plus I hate doing that work. It's just a waste of everybody's money. And so do it right. It's not that expensive. And now you have your business ready to go to get your bank accounts, get your customers, get everything going.
So if you do use LegalZoom or something like that, what you're saying as a lawyer could be fine. How do you know that you're doing it right? I think that's the big question.
Yeah, that is a good question, and it's a big question. How do you know you're doing it right? You should have a lawyer actually look at the documents. If you know what you're doing and have done it before, a place like LegalZoom works perfectly fine.
Okay.
If you've never done it before, many times you're getting the core of your formation, and that's fine up front. But the odds are you're going to have to redo something later because you won't have done it right. And I'll just give you one really good example. How many shares do you start with? If it's just you, how about one? Does that work? Yeah, usually it works until you want to share it with your wife, and then you try to split that one into half, which doesn't exist. And so the problem with that is now you just have to spend more money to amend your certificate and do the kind of things that if you had done it right in the first place, you would have saved more money.
So can we give people a ballpark about what they should expect to do it with a LegalZoom plus a professional review or whatever it is? Like, and I know the real answer is it depends, right? But for people who are like, gosh, I don't know. Like, is there some ballpark of what's reasonable?
Sure. So the answer is it depends.
Okay.
But no, there's a reasonableness number. So when we're forming what we consider family-owned LLCs, which is a limited liability company, it costs approximately $525 to $550, and that includes the filing fee. If you're forming a corporation, then it's about the same, give or take $25 to $50 for us. Now, again, remember this is very rough, and it depends on what you're doing later. And this is assuming you are in Texas. All these things change depending on where you are because fees change. But it goes up from there. If you have 3 non-related founding members, your cost is probably going to be closer to $1,000 because you have a whole different set of documents. Now, that's not the air quote going rate for those things. That's in general what we charge as our firm. But it can be anywhere. I've seen formations cost $8,000 for people. I mean,
if you have a bunch of venture capital, suddenly it gets extremely expensive, I'm guessing.
That's absolutely correct.
Both for good reasons and bad reasons.
Not just venture. Yeah, that's exactly right. Not just venture capital, but investors. Even if you have angels that come in, it starts costing more. But what we're really talking about is the first day formation. And the odds of you having the VC in there are almost zero. Or even the odds of having an investor day one is relatively low. Out of probably the 1,000 we formed, there's probably been 10 that have actually had true external investors on day one.
And they can afford to have a lawyer.
By
definition. So if I'm hearing this right, it's $300-ish to form an entity, which you're insane not to do. And that's the professional legal terminology, in my opinion. And it's an additional, let's say, $200-ish bucks if you're starting like, hey, I'm going to do consulting out of my house. And it's an additional $500-ish bucks if you are forming a company with some friends.
Yeah, that's about right. And again, a lot of this depends on how much you want to talk.
Right.
So if you want to talk about it for hours, which I have friends that want to talk about this stuff because they're interested, it just goes from there. And as a firm, we don't actually do fixed price, which you could theoretically do. But my view has always been fixed price is much like the tech world. If you do a fixed price consulting engagement, you bake in 40 to 50% margin. And we just don't do that. So what that takes away is the theoretical 5 hours of questioning that some people want to get in the weeds about. But your numbers are about right for what our firm does. Now, keep in mind, we're not a normal firm.
So I'm just going to say, if you are out there, especially if you're in Texas, and you haven't put together the entity formation documents, you haven't had a lawyer look at them, stop being insane and talk to Brian. I don't usually make direct plugs like this, but it's not like we're talking about $10,000 or $20,000, right? We're talking about a couple $100 per person. Order of magnitude, right?
That's about right. That's a good way to look at it, and that's exactly what I would do.
So, okay, please, if you're listening to this and you haven't done this, press pause, pull off to the side of the road, stop jogging, get off the treadmill, whatever it is you're doing, and get this taken care of. Because the next thing you know, like the last thing you want is for someone to be able to come after your house or other aspects of your livelihood. So. And actually, I wasn't prepared for that answer. I thought it was going to be a lot more expensive. So I'm really like, hey, guys, go do this. right? If you're forming a company with some buddies, you're going to go out and have dinner and have some drinks. You're going to spend almost as much doing that as actually forming the company.
Yeah, that's accurate. Now, keep in mind, there's a lot of law firms that are going to give you a different answer, and they provide good product too. It's just we've gotten it down to, from the tech perspective, a process that is repeatable.
Right. Very good. So let's assume that we have an entity formed. What's the next time that someone should be thinking about talking to you?
Yeah, this is an interesting question too. Anytime you put your signature on a piece of paper, it should have been reviewed by a lawyer first. I can't tell you how many times I've looked at contracts that someone has signed, and you look at it and say, well, I signed it. It's just an NDA. It's just a non-disclosure agreement. What could possibly go wrong? And you start digging, and you have people that put provisions in non-disclosure agreements that don't belong there. For instance, assigning something that you may have created to them. Mm-hmm. Not appropriate place for that in an NDA, but it happens all the time. So when should you talk to us? Well, when I look at our client base, I usually have them they spend money in month 1, and they don't spend any money with us for month 2, month 3, month 4. They maybe have a little blip. But where you should start talking to your lawyer is anytime you start getting into a position where you're going to sign a contract, mm-hmm. where you're going to create intellectual property that needs to be protected, which includes patents or trademarks. Really, those are the two main ones. Copyright and some of the other pieces are a little less important, but not important from a protection perspective, but less important to talk to your lawyers about. And really, though, when you start your business, it's getting those first contracts in place. So let's say you're hiring a consultant to help you write or help you design your website or help you design your first product. You should have a contract for that. In fact, you have to have a contract for that. Go back to my first comment about protecting yourself. You've got to have contracts for those kinds of things. So you come back to us and you say, hey, I need a consulting agreement for somebody providing a service, or I need an NDA because I am going to go talk to that first investor. That's when you start talking to us again. And you start getting the types of contracts that you need. And we don't, as a law firm, sell what we consider the startup package, because mm-hmm. we're not a package company. We sell you what you need when you need it, and don't buy it until you need it. It has always been my philosophy. Keep your own money in your own pocket. Don't put it in mine. That's a horrible way for a lawyer to speak, I suppose. But truly, I want you to use your money on AdWords and those kinds of things, because my belief is if you get your business going and you start spending money on lawyers later, use them when you need them, but spend the money that you need later for that lawyer, and you spend your money on your developers or whatever you're working with, you're going to spend more money with me faster later.
Right.
So that's always been my view.
Okay, fair enough. Now, one thing that I get asked about a lot is proposals and contracts, right? So, because that's what my customers are creating. And a lot of them, I realize, are coming to me because they're like, I feel like I should have a contract. I feel like I should have terms and conditions. Like, they're not trying to optimize. They're trying to literally have something. Why don't they have anything?
Well, they tend to be scared is the first one. Okay. Scared that it's going to cost too much is usually the answer I get from folks that are not friends, that just are acquaintances, is I'm terrified that I pick up the phone and call my lawyer and it's going to cost me $300, $500 every time I pick up that phone.
Just to explain what my problem is.
Yes. Yes. And the answer from our perspective is you should have a contract for those things. Or you're writing a proposal, you should have a footer on your proposal that says something like, this isn't a contract.
Right.
That's actually the opposite side of that. And so to me, the reason people don't is, one, they're scared. And I don't mean that in the terrified sense. They're just scared it's going to cost them too much money. And then 2, they think it's going to take too much time. And 3, they think their lawyer is going to muck up their deal. Mm-hmm. All 3 of which have happened to people.
Right.
And so they take those, I'm sure there's other points, but they take those 3 and they say, you know what, I'll just wing it. Or I'll just go find something on the web and use that, and it's good enough. And maybe it is, and maybe it isn't. And it's probably good enough if nothing goes wrong. But if something goes wrong and you haven't thought through what you're trying to protect, or even defaulted to a good protection type contract, you might be in trouble.
Right.
Go back to number 1, where please have your entity in place. So it's your entity in trouble, not you personally. But I think that's the main reason.
That probably makes sense. And I think a lot of it also is people don't necessarily, when you're selling stuff, and this is what this lawyer explained to me when he was helping me set up my entity and my contract documents and so on. It's like, you always you're hopeful for the best. And you spend so much time thinking about the path to the solution that you don't want to think about all the ways that you can fall off that path. And it's sort of the lawyer's job, who has seen all the wreckage in the ditches on the side of the road, to say, we have to be prepared if these things happen, that it turns into a minor inconvenience and not a catastrophe for everybody.
Yeah, and that's a great way to put it. I always view myself as a marriage business lawyer, right? I'm putting contracts in place or businesses in place so that people form together, but you have to be ready for the divorce. And so in a lot of ways, it's kind of like a prenup. Right. I don't do any of that kind of work, but it's very similar. You are all flowers and everything's going to work really well. And hopefully it will. And to be honest, it's 95+% of all contracts. It's probably 99+% of all contracts are just fine. And the deals go fine. But that 1%, as long as you don't ever end up in that place. But what I've heard people say is you are not a legitimate business person until you've been sued or sued somebody. Now, I don't necessarily agree with that, but it's very true. It's something that is inevitable in business because every deal does not go perfectly. No matter how good you are, it doesn't matter. Things just go wrong. And
I guess one thing I would say is you don't necessarily have to get all the way to a lawsuit for things to go sideways and cause a lot of pain and cost and trouble. And hopefully you don't get involved in a lawsuit, but if you're in business for any length of time, you will have disputes that will cause problems, that will involve money changing hands or not changing hands that not everyone agrees about.
Absolutely true too. And when you can point back to your contract and say, hey, the contract says blank, it's significantly better than just having nothing and saying, oh, well, we're just going to fight about it.
Right.
And you can save, I can't tell you the number of people that have said, oh, we saved money because we decided to put X in a contract. Or we decided not to put it in there because we thought nothing would go wrong and that cost us X.
Right.
It goes both ways. And you're exactly right. Most disputes don't go to a jury trial at the end, right? And in fact, in 20 plus years, I have not one contract that has ever gone to a jury trial. Don't get me wrong, they've been in disputes, but everything has settled at some point during the process. There have been lawsuits, but I've never had a client on a contract dispute go to a jury trial. That seems crazy.
Right. But that's kind of like, I think when people think about that, they're like, well, I'm not going to end up on an episode of Law and Order.
Right.
And it's like, well, that's not really where you're going to end up. You're going to end up not getting paid.
That is the most likely scenario, not getting paid and trying to collect.
Right. And it's probably going to be for a much greater amount than having having a great contract doesn't guarantee anything, but I almost feel like, because I read a lot of these documents now, not just for myself, but for my customers. And it's like you can almost tell who's setting themselves up for trouble, not just in the legal language itself, but in how they draw up the contract or the proposal, right? Like some people have a real clear idea of who's going to do what when. Yep. And some people are like, we're starting here, we're going to get over there somehow, and we're going to magically leap across this chasm. And when we get there, everything's going to be great.
Yeah, that's exactly right.
And a lot of businesses, they're smart and they've been really successful that way.
Yes.
But it's kind of like, I'm not a lawyer, but I can tell people are setting themselves up for trouble because they're not laying out the steps of how they're actually going to get across this canyon.
Yeah, that's very true. And now we're kind of digressing from the contract itself, but a lot of that kind of relationship is relationship based. Mm-hmm. And the second your business champion disappears, right, i.e. goes to another company, gets promoted, gets demoted, gets whatever, all of a sudden you're in a really different position if you're the service provider where you're relying on a relationship to get yourself paid. Now you have a new guy coming in who doesn't want to spend the money.
Right.
And it has nothing to do with how you performed. It's just a money thing now.
Well, and it's also, if you don't have a clear vision of here's why we're doing this, it was just Bob's pet project, then you're in big trouble. Versus if you go in and say, here's why Bob was doing this project because of X and Y and Z, and here's the progress that we've made, and here we go, you have a much better chance of getting to continue. It's not guaranteed, but it's like, I don't approach this from the legal side because I can't give any legal advice, but I approach it from the human common sense side Like if you were the new guy coming in, what would make you feel more comfortable and want to continue?
It's great logic, and it is the way to think about it from a business management perspective.
Right. So let's suppose we've got our entity formed, we've got our contract set up. How can we have a standard contract and say, here it is, or do we have to review it each time?
Oh, I use plug and play. So in general, my contracts are reusable. I don't lock anything. I hand you a contract and say, hey, you need to change the names, change the business terms. I've even gotten to the point with some types of contracts where we create an order form effectively on page 1 and terms and conditions on page 2, 3, 4, 5, however many pages there are. And the reason I do that is because the order form has the business terms. That's you. That's not me.
Right.
I don't care what your business terms are. I will help as much as possible. I've seen an infinite number of types of deals. But if the term is a year and you want to write January 1st to December 31st, you don't need me to do that.
Right.
You don't even need to write the name of the customer. You don't need me for any of those things. And so to me, you create a form that has a set of variables. Mm-hmm. Again, I am an engineer originally. And so I have done it at an efficient, I use efficiencies to do these things. And so I give you 10 blanks, 5 blanks, whatever your business is, you have a set of blanks and you fill in the blanks, not me. You don't need me to come back and bill you to create a contract for a customer. Now, don't get me wrong. I have customers that use us because we're their general counsel for that form, which is fine. And we have that type of relationship. And either they don't have sales guys that they trust to do that, which is not a knock on sales guys, but they want more control. Maybe the CEO has one guy that he wants to create all these things and he's made it his lawyer. But in general, my view is to give you the tools you need to never come back until you have the issues that you need. So negotiate it or that type of thing. And I also like to, I wouldn't use the word train, but give you enough knowledge that you feel comfortable writing $10,000 as the dollar amount. Right? And so that's the way I try to create contracts. And I call them plug and play. There's a huge number of different things you can call them. But that's my view. Make it easy for my customer, my client, to reuse stuff.
Right.
And I will tell you, I don't lock anything. And my funniest contract, I had a round trip contract that was my template for services that came back to me from the other side. So my guy was the customer through England. So from Austin, somewhere else, I couldn't even track where it all came from. But my contract came back to me for one of my my clients as the customer when it was designed as a service provider. A vendor contract. And of course, I don't necessarily like that contract that way, but no clue who the people were, no clue how they got it, no idea how it hopped from me all the way, across the pond and back. But again, that's fine. I don't mind. It's just
like someone
weird.
Brilliant wrote this contract.
Exactly. I thought so.
Now, I don't want to bore the listeners here, but you and I should have a separate conversation about embedding these contracts in my software. So it really is completely plug and play.
Yeah, we'll do.
So let's say we've got the contract set up. We're ready to rock and roll. We've plugged in the numbers for this deal. And then the customer comes back or the prospect comes back and says, that's great, but now you need to put stuff on our paper. What happens at that point?
Yeah, so
call you again?
Call us again. So once it goes on customer paper in that scenario, you have to start over, right? So you have to start with a review of the contract. And I'll be honest, I mean, that's where your costs start going up because each page costs some amount of time to read. And I always tell people, and this is incredibly rough and it's not particularly accurate, but it takes about 1/10 of an hour per page to do contract review. If a page is an exhibit and has one line, obviously that doesn't take 1/10 of an hour. But in general, you get to the miscellaneous section, it's a little faster. You get to things like indemnification, it's a little slower. So in general, you give us a 10-page contract. It takes about an hour, give or take, to review it. And so that's where you have to start incurring cost. But I will tell you, in general, templates on either side are better for the party that's providing the template.
Right.
And so you'll have provisions that are very one-sided in almost every deal.
Right.
And so you can't just sign Fortune 500 companies paper because you may be giving away your whole company. Right. Some of them are so broad that you truly may be giving away significantly more than you expected. And you may be incurring more liability than you thought you were.
Right.
And things like insurance, they may ask for a $25 million policy and you're 3 guys.
Right.
Like, you don't have a $25 million policy and they don't really need it.
Right.
But they ask for it because it's in their template. So that's where you would send the agreement back to us. We redline. I use the comment feature in Word or Google Docs now. But whatever format you like, we tend to use. And we use the comment feature and say, hey, can you accept net 90-day payment terms? Can you truly be a quarter and a half out before you get your first payment? And some people can, some people can't. But we flag that kind of stuff because that's a true business issue, not a legal issue. But we flag those kinds of things and then redline the legal issues, for instance, limited liability and indemnification. And when we're starting to work with somebody, we get a feel for what their risk tolerance is. So the first time is always the hardest,
right?
Because we don't know a lot of times we don't know what you do until we get the first contract back from a customer and go, okay, now what the heck are you guys doing? And that's where you would start. You would bring that back. But again, it goes back to when do you send something to your lawyer if you're signing it?
Right. And I think the takeaway is, for a lot of people, just because some giant company is sending you a very formal looking document, you don't have to sign it. You certainly don't have to sign it without reviewing it with your lawyer. And if you're signing a $100,000 contract or whatever, spending $500 or $1,000 or whatever to have it reviewed might well be a good investment. Just a thought.
Yeah, it's just a thought. It's recommended to do that, but it's up to you.
And I know, back in the day when we were at Trilogy, we would be looking at these deals of just, huge deals that just in crazy amounts of money. And I remember there were times when they wouldn't sign them because they were like, the whole company is on the hook and they can put us out of business. So we cannot sign any contract, no matter how much money is involved, if they can put us out of business.
Yeah. And it's a great point. And your point, Ruben, is big contracts are like that, but it goes the other way too. If you're signing a $20,000 deal with $20 million of liability, it might not be a good deal.
Right.
It may be the deal you want right now, but it may cost you in an acquisition $250,000 of value.
Right.
Because you have this contract that's an outlier, and it's not just about today, but if you sign horrible contracts in due diligence in an acquisition, you very well may be flagged for not even being able to be acquired.
Right.
And I will tell you what we do, or what I do when I'm on the acquire side. This is kind of a trade secret, but kind of not. If I see those kind of contracts, you know what I do? I go back and go, you know what? I'm going to pay for my legal fee for this review by just saying, hey, we're not getting the price down of this acquisition by $250,000 because of this horrible contract.
Right.
And you know what? I almost guarantee you that we're going to get some money out of that.
Right.
Right. Some dollar amount will come off the purchase price because the contract is so bad. And if it was a $10,000 deal for you that just cost you $250,000, that doesn't look so good.
Right. And I guess whether or not you should take the $10,000, which you might, you shouldn't take it just blindly accepting the $20 million of liability.
Absolutely. You have to think about it. It may be worth it.
Right.
There may be little risk associated with it, but you certainly want to think about it as opposed to just signing it. And you want to know why. You want to know why you're taking that risk.
Right. What has happened at that company that they require so much liability? Like, do people fall off ladders regularly?
Right. That's a great point.
And a lot of the stuff, especially for the tech people, I see what I think is a sort of a vestige of if someone's going to a place, they're going to go work on some machinery and they're worried about someone's arm getting cut off or something. Right. Versus I'm going to sit at a desk and my worst risk is carpal tunnel or something like that. Right.
And you do see that a lot in just template services agreements. They really do sound like somebody standing on a ladder changing a light bulb as opposed to someone sitting at a desk. And you do see that a lot. And a lot of times maybe that risk it's worth taking, or the risk of you're never going to be on site. And They have a provision that says if you're on site, X, Y, and Z. Well, you're never going to be on site. Now, do you like those provisions and contracts? Not really, but if you're never going to be there, your risk is a little bit lower than if you're there every day.
Right.
And certainly if you're not changing the light bulbs.
Right. And some of it depends on what you're doing also, right? Like you could be remote and not on site and not at risk of falling off a ladder, but you're working on extremely sensitive source code with access to crazy data, and you don't want that to end up in a hacker's forum in Russia and so on, right? Like there's another set of liabilities that could come into play.
That's absolutely true.
So what do you do? Like, and I don't know, I'm not a lawyer, as I've mentioned once or twice, but I feel like so many of these customer contracts are written from like 30 years ago. and don't necessarily address what is actually happening today, right? Like I'm not on a ladder, but there are actually legitimate things that maybe we should discuss and make sure we have a plan for, and that I'm going to agree to the following. Like I actually want to agree to certain provisions to protect your information, for example,
right.
So that you know that I'm doing the following things, but they may not have any idea of what that should be.
Yeah, the bigger the companies these days, they have a pretty good feel for data security obligations and protection of PII, but your personal information. But they're still using contracts, to your point, that feel like they're from 1985. And you got to put those two things together. So what they've done is they've just slapped exhibits at the end that are actually above and beyond what you probably do. So I'll tell you, when I get, especially a Fortune 500 company, they've been very thorough with their data access type provisions, but they're also impossible to follow through with. And so what I do in those is, especially if it's exhibit A through E of data access and it's 45 pages, I read them. I read every single one. If you work with me, I use the word designed to a lot because, again, not going back to, I am originally a tech guy, and you can design stuff to not fail. So I was mechanical. So you designed the bridge not to fail.
Good idea.
But the bridge, you're not guaranteeing that the bridge won't fail. And so in contracts, it's a little trick I've used, and again, giving away a couple of trade secrets, but I use that the service provider will create protection mechanisms designed to prevent hacking. But you all know we can't prevent hacking.
Right.
And the target, if it's a Fortune 500, is not your company. The target is the Fortune 500. And if you happen to be the person that somebody, Russian hackers or whoever it happens to be, I don't care who it is, who gets to a Fortune 500 through you just because you happen to be there, whose fault is that? If you've done everything you could do, but a foreign government decides that they're going to attack, there's nothing you can do about it. And so in those contracts with those guys, they've created a mechanism where it pushes all the blame to you and all the obligation, which, to be frank, it would put you out of business. If that happened, you'd be out of business if you didn't have protection provisions in your contract. And even there, you're probably still at such a high multiple of your value or your cash that you're going out of business anyway. But they've done those things to try to create a mechanism. But what I will tell you is read it. So you, as the tech people, have to actually understand what strong encryption protections you need, where you cannot put PII, like if you can't use it on a mobile device, or if you have to have mobile devices with strong encryption, or it's got to be encrypted in transit. All the things that most lawyers don't actually understand what's going on. And me being in the space, I understand it, but not the details of how you use strong encryption or encryption in transit or those kinds of things. And so what I do is I point out all of those pieces, and I use my design to all over the place. But you point out all those pieces and go, hey guys, do you have a business continuity plan that does X, Y, and Z? And if you don't, well, I've got one that we can start with, and let's use that as our business continuity plan. But those contracts make you say contractually that you have all those things. Now, back to Ruben's point originally, if you have a contract that says that and they owe you money and they go, well, hey, you know what? We're just going to ask for your business continuity plan now. And you say, oh, I don't have one of those. Well, now two wrongs don't make a right, but two breaches kind of make, oh, who's going to pay? I don't know. You're in breach too. Whose fault is it? I don't know. So it goes back to, it is important if you say you're going to have something that you have it. It's important to encrypt if you say you're going to encrypt. Right. It's important for the technical guys to actually read contracts when it's very specific to a technical service or a technical thing that you do.
Kind of goes back to the whole, let's read this thing before we sign it and push back on stuff that isn't reasonable or that we don't have or that we think doesn't apply.
Very true. And remember what it says. So one of the things that people have started doing is you can never get rid of your machines. So if you ever have my PII on your machine, you cannot get rid of the machine without my written permission. Come on now. How is that really? Do they really care? Right. So what do? You obfuscate. There's other ways around that. There's the technical guys know how to fix that problem. what the goal is that you're not handing over their PII.
Sure.
But there's other solutions than I have to keep now a storage closet full of old computers because that happen to have something on it.
Which sounds very insecure inherently.
Which is highly insecure, right? But that's what they've decided. Oh, that's their protection mechanism because now they think they have control. But now you got a closet full of Social Security numbers. I don't know what it would be.
Right.
But you got a very insecure method.
Right.
So again, read it and remember. You have to actually remember it because let's say you did sign up to that, you have that obligation.
Yeah, that makes a lot of sense. Now, something that I hear from people after the fact a lot is like, I had a bad feeling, like something just didn't feel right, and so on. And you probably hear this a lot more than I do, actually. Yes. Like, what are some of the signs that people should be looking for that maybe are a little, like one step more concrete than I have a bad feeling, but I really want the money?
Yeah, the biggest ones are when you start seeing, and this is hard to say to the business side. It's more. I hate to say this. It's more of a feel on the legal side. But when a service provider, for instance, is unwilling to sign up to very standard terms in the industry. So, for instance, one of the things that's highly common is carving out breach of confidentiality from your cap on damages. It's highly, highly common. And sometimes people push back, but when they keep pushing and pushing and pushing, and when they come back with, well, if we screw up your confidential information, how can we be on the hook for an unlimited amount of money? It's a red flag that says, well, maybe they don't think your confidential information is that important to them to protect. And so I hate to say that it's actually a gut feel for me too, but it's a gut feel based on flags of standardized type language. And I'll also be honest here. My version of standardized is very different than other people's. I was actually on a call today where they were talking about, oh, this is standard in the industry. And I've done 5,000 agreements, and standard in whose industry, I have no idea, but not the IT services industry, which is where the service provider is coming from. But it's a huge red flag. And the example I would give there is there's in this specific contract, there's things are reversed. So they're pushing the liability the wrong direction. And when you see that and they push back really hard on that kind of thing, it's a red flag that they either one, they stink at what they do. But two, it could be something's happened in the past. And so they've been burned on something.
Right.
Which might mean that they're more protective of it, or it might mean that they don't know how to protect it. And so it's really, gut is really the most important thing, because when you start getting those gut reactions, in general, you're right. There's a feeling that you get from customer service providers. Either way, it goes both ways, by the way. People, right? And it goes customer wise too. If you get a feeling you're not going to get paid, you're probably not going to get paid. Mm-hmm. And when people are pushing back on those kinds of provisions, hey, we're not going to pay you for the first time for 120 days. Well, you're 6 months in,
right?
You didn't just sign a $50,000 deal. You signed 6 months of free service.
Right.
And so it is a feel thing. And other than that, it's really, are they pushing for things that you don't consider standard in your industry?
And again, I am not a lawyer, but one thing I've noticed doing a lot of projects with a lot of different customers is there are some customers where I feel like I'm talking to a person. I'm having a temporary marriage, as you put it earlier, so romantically. And just like, here's why we say this, can you reassure me that our data is protected? We don't care if we don't actually want your machine to lay in a closet or whatever, but it's clear that they want to work with you to achieve a reasonable result.
Yes.
And then there's other cases where I feel like there isn't, for me, the big red flag is, are we trying to work together to achieve a reasonable result? Or is somebody they are just tied up in something that is tangential to the final result, and in fact, often in opposition to it, because whatever their incentives are, or whatever way they're wired, they really care about this other issue that's going to cause a big problem and to make it harder for you to get to where you need to go.
Yeah, that's a good point. And I don't know if you've seen this, Ruben, too, but the larger the organization, the more of that I see.
Right.
So the smaller the organization, in general, everybody is responsible for everything. The larger the organization, you have your own little silos and you protect your silo.
Right.
And these projects get, especially the bigger the project and the bigger the customer, the more people have their own agendas that may not be worked together to come to a solution that's good for everybody. And you can get that feel too from the individuals.
And it's one of those things where you really want the relationship with a project champion who's going to help walk you through and navigate this solution. knowing all the different agendas going on much better than you ever will. But to your point, you have to be prepared if that person goes away. One of the things I screwed up at one point was I had a great relationship with this project champion. I mean, we worked our asses off for him. He got great results. Everyone was super happy. And all kinds of crazy stuff was going on in the market and the organization. Nothing bad, but things were changing and we were responding, and he was just thrilled with how we were reacting. And we did a couple of handshakes to see. He was like, whatever you do, don't even send me another contract. Just keep doing what you're doing. Don't worry about it. I trust you guys. Guess what happened when he got reassigned?
Yeah.
And accounting came in and said, why are you over budget?
Right.
And the whole, well, we had this great thing going that was awesome where we really felt like we were delivering great value. And in that case, it all worked out fine and we got paid everything we were owed. But it sort of turned this sort of triumphant project into another meeting where accounting is raking me over the coals and questioning every line item in this invoice. And it just wasn't worth it.
Right. And that's absolutely true. And then if you get the lawyers involved too, it gets even worse. So you got the accountants going through every line item, and then you have the lawyers saying, well, we didn't say we were going to pay for that.
Right.
And that, again, it goes back to I'll be truthful here. If someone wants to come in and say, hey, we're trying to figure out a way not to pay this, we're going to go through the contract and say, here's the reason we're not going to pay for this.
Right.
We're going to point to something that says, who knows what it's going to say, but we're going to find something or try to find something. And if you have a bad contract or things like, to my satisfaction.
Right. I'm not satisfied.
I'm not satisfied. Not satisfied with the bill. And so you point to those kinds of things. And that's actually a good one too. Satisfaction is a horrible contract term if you're a service provider.
Right.
Or sole discretion. Also horrible.
So, and that actually brings me to something I was like, I don't know if I want to talk about this with Brian, but there's one invoice in my whole career that didn't get paid. And it still bothers me a little bit. And we had the contract in place. This was like a repeat client, and everyone was happy. And they referred us to other people in their team, and it was great. And then we wrapped up the project, and we sent the last invoice, and we had already. Fortunately, we got paid half up front, but then the half at the end, they're like, refer to accounts payable. And these people that we had been working with for months, and everything was great, and accounts payable was kind of like, yeah, these guys kind of screwed you over. I'll give you half. So we got 75%, but it still bothers me. And it was and so like my calculus was, it will cost me more to go get that money than what we were owed, because it wasn't a huge amount of money. It was more just the principle of it.
Yep.
But there is the chance that you're going to be in a situation like that where someone's just like, no, we're not going to pay you. We dare you to sue us.
Yes. And what they're looking for there is they know the cost of suit is expensive. And our firm is not a litigation firm, though we do early stage dispute type stuff for our clients. And the theory there is exactly what you described. It's going to cost you $7,500 to chase $12,000 and you're going to get $6,000.
Right.
So what do you want to do? What do you want to take? You want to take $6,000 right now and not spend the $75,000? You want to take $5,000 right now?
Right.
And the sad part is the right business answer is not necessarily the right answer. And the right business answer is typically, depending on what the scenario is, but the right business answer a lot of times is not the right legal answer or the right ethical answer,
right,
or the right answer that doesn't burn you still,
right,
years later. And so unfortunately, litigation has become expensive, and it's really I mentioned the point that nothing goes to trial. Very few things go to trial. You obviously hear the big splashy ones, but very few things go to trial, which means you don't get to the pay attorney's fees type provisions. You get settlement type things, and so everybody's paying their own fees.
Right. And
so you're stuck in the position of making a good business decision. Now, keep in mind, it costs them money too. Mm-hmm. So it's not like you're spending, and this is where it gets really weird. You're both spending $7,500 to get $6,000. So everybody spent $15,000 on lawyers to get $6,000 net, which is a horrible answer at the end of the day.
Right.
Like that's net to the economy. Well, I suppose it goes to the lawyers, which is positive for the economy, but in general, that's a net negative in my opinion.
Right.
You've actually spent a lot of money to do nothing.
Right.
And I'm not a fan of that. And so one of the ways we've kind of tried to get around that angle is we have a breach template. And, you write your own couple of paragraphs and then the letter comes from us. But you write a couple of paragraphs about what happened and we throw in the legal stuff. We'll take all actions at law and equity, the things everybody has seen, and we throw them in and we say, hey, you write it. It's easier for us to edit your description rather than you spending an hour describing it to us and we write it and then you have to rewrite it. And so we try to get around the cost side. It's not a solution. It's just one of the things. It's an evil that happens. And the scenario you described for what happened to you, it happens all the time.
Yep.
And it's not right. It's not, it's part of this business world.
Right.
And as the economies change, it was worse in 2008. It happened a lot in 2008 where people just went, you know what, we're at the end of the project. What are you going to do about it?
Yep.
And it's, again, it's not right, but it is.
And as you can tell, it still bothers me like a decade later. But, if we hadn't had a decent contract and we hadn't got paid half up front, we probably would have been out the whole thing instead of about 25%. And so for me, it's more about the principle than the money.
Right.
But gosh, if we'd been out the whole thing, it would definitely have been about the money.
Yeah, absolutely. And you're right. If you hadn't had a good contract, you'd probably been the other side. You might not have gotten 0, but you probably would have been 25%.
Right.
Instead of 25% missing, you'd have gotten 25%. Right. And your net would probably have been, you're good there, right? That's that you still would have been net positive at that 25% after you spent all the money, potentially, which is horrible.
Well, I didn't mean to get into this dark Law and Order territory. I want to just say that I like the wine. Like, one of the challenges I have with these interviews is that you open up the wine and when you start, it's not decanted or anything. Right. Especially if you have a Malbec or something. It really starts getting good about the time we're wrapping up, which is so unfair and kind of goes back to the whole notion of we should do this over steak or something and decant it ahead of time. And I'll get there. I'm working on it.
Fair point. This is a good wine though. I am enjoying this.
Yeah, it's really smooth now. It's nice. It's it's got a lot of body, but it's not bitter. It's not overpowering.
No.
And again, maybe we have to do a field trip to Argentina.
Okay, I'm in.
We can go in the summer. We can leave Texas in the summer, go down there and have winter there, have some beef and some wine, and go to the mountains.
Sounds perfect.
Oh, Brian, any other advice for people? This has been super helpful for me, and I like to think that I know this stuff, but what else have I missed that people should really make sure they cover?
I have one last bit, which is your lawyer should be someone that you like to interact with. I say this to clients all the time. If you don't like me, please don't work with me, and vice versa. And so you spend too much time dealing with people that you don't like, that you have to deal with. Customers, vendors, who knows? Pick your lawyer from somebody that is good at what they do. That's number one. But 2, someone that you can sit down and have wine with. And I always tell people that if you can't sit down with me and have a conversation about your kids or the weather or sports or whatever we're interested in, whether we do or not is somewhat irrelevant. If we can't sit down and have that conversation, go find somebody else to work with. Life's too short to work with people that you can choose that you don't like. And so when you're choosing your lawyer, again, find somebody that's competent. There's a lot of competent lawyers out there, but find somebody that you actually like too, unless you're doing something like hardcore litigation where you just need a bulldog or something of the sort. But in general, if it's somebody that's your business marriage lawyer, like working with them. There's plenty of them that can do a good job that you can interact with at a professional level and at a personal level.
So someone that you will actually want to pick up the phone and say, gosh, I have a problem. I really want to call my lawyer, as opposed to, I got to call my lawyer.
Yeah. And it's more, yes, exactly. And you can start the conversation talking about your kids or that you just got back from wherever, and you don't feel like they turn the clock on. And my wife
do they turn the clock on?
Some of them do.
Okay.
Again, my wife asks all the time. She's like, when do you turn the clock? How do you know? How do you know when the clock turns on? Because sometimes you talk for 15 minutes with people about stuff, and you just when you're done talking about this stuff because they're friends or business friends, then you start the clock. And one of the ways we do that is we don't have round up or round down type numbers. So we don't round to minutes. We actually bill in 0.05 increments. My partner actually hits the little timer, and if it's 11 minutes, it's 11 minutes. I'm slightly less than that because I'm 0.05. But if something's 9 minutes, it's 9 minutes, and then you don't have to worry about picking up the phone and calling and knowing it's going to cost you 30 minutes of time. But a lot of people have a different business model, so you choose who you like to work with, and hopefully it all works out.
Well, Brian, thanks so much for taking the time. I hope you didn't start the timer on me because all I brought was this bottle of Malbec. I'm pretty sure it does not cover your fees, but cheers. Thanks so much.
Thank you, Ruben.